Let's get into it. So what this is referring to, we have to back up a little bit. The lively parties subpoenaed a host of third-party witnesses that relate to Wayfarer parties. So these are individuals, I don't exactly know who a lot of them are, but there's a list of individuals that were apparently given a subpoena or served a subpoena and asked to produce certain documents, materials responsive to those subpoenas. And the lively parties moved to compel those third parties to produce the relevant documents pursuant to their power to do so in the federal court discovery process. And the judge today said, each of these third parties are governed by the jurisdictions that they're in. So if you are serving a third party subpoena on someone that lives in Los Angeles, then that person's the jurisdiction that person lives in, Los Angeles, governs the compliance with that subpoena, aka you need to go to the court that's relevant to that person. So if you third party subpoenaed someone in LA, you need to go to a court in LA to compel compliance with that subpoena. I think one of them was in Atlanta, but most of them are in LA. So the court basically punted it back and said, you need to deal with this in the respective jurisdictions that these people reside in. So they did that, and Katie found the other docket. So the docket that we are referring to is the lively Wayfarer docket. That's the docket that's basically the register that the court uses, for lack of a better way of explaining, for all of the filings. And that's how you see like filing 1, filing 200, filing 367, whatever. So all of that is everything that's happening in a particular case. A completely separate docket, it relates to a completely separate case. So it's not been consolidated. They're happening on separate tracks, maybe parallel, but separate. For example, the Judd Wallace case is on a separate parallel track. It has a separate docket. And so with respect to some of the subpoenas, they are going to be on different tracks simultaneously happening with this case. So Katie found the docket relating to a stipulation. It's a joint stipulation pursuant to local rules, which is how each court has its own local rules. And essentially, they're bringing to the court this argument for the court to resolve their discovery dispute. So what happened was the lively parties subpoenaed all these third-party people. We don't know who they are exactly, but all these third-party people. They also subpoenaed Freedman's law firm. So they sought documents that they believe are responsive or relevant to their claims. Specifically, they're essentially claiming in this argument, in this motion to compel, that Freedman or his firm or agents of his firm colluded with the Wayfarer parties to continue to retaliate and smear Blake Lively in the media. They're asking for a whole list of documents that would help to prove that this is still happening and that Freedman is not just acting as an attorney for the Wayfarer parties, but he's actually one of the co-conspirators or one of the people that is perpetuating the retaliation or smear campaign that they're alleging against the Wayfarer parties. Because remember, in her amended complaint, she says that the retaliation is ongoing to today, to tomorrow, that it didn't stop, that it's continuing. So this is part of that. They're alleging that Freedman's actions, his law firm's actions, are perpetuating that retaliation. And so they want documents to be able to prove that. I just want to take a breath and a timeout to say that subpoenaing your opponent's lawyer, that's like the telltale sign that we are in scorched earth litigation land, where everything is on fire, everything will be put on fire, so that the other side has to expend all possible resources to put out the fires. Literally, you can think of it as one party setting out 25 fires and they only have 15 firefighters to fight them. It could be a strategic move to exhaust the other side under paperwork or just expense and headache, potentially humiliation. So that's one thing. But to actually subpoena the documents of the person's lawyer who you're suing, that's pretty rare. And that usually is a sign that things are getting a little dirty. For the sake of this, let's assume that they have good reason to believe that the law firm is colluding with the parties to continue this retaliation, alleged retaliation. So they are seeking documents to be able to prove that. Well, that's fine. They can do that. But when you are seeking documents that are potentially privileged, potentially work product privilege in some way, there's a higher standard. And that's what the Shelton test and the Freedman test are referring to. So these are two different cases. The Shelton test is used in the Eighth Circuit and also referenced by other circuits. And the Freedman case is used in the Second Circuit, or there came out of cases in those districts, but other districts will refer to both tests. And the Ninth Circuit, which is where California sits, has used the Shelton test and the Freedman test. They're tests to determine whether or not something is permissible. Discovery to lawyers is permissible in these situations. So the Shelton test requires a party that's seeking discovery from an opposing counsel to show that there's no other means by which the information could be obtained. They also have to show that that information sought is relevant and that it's not privileged, which is a whole can of worms, whether or not something is privileged, because most things are going to fall under privileged. And that information is crucial to the preparation of the case. So it's actually a pretty high standard that somebody has to meet and show when moving to compel documents that are in the possession or control of an opposing counsel in a case. The Freedman test, it reads a bit weaker in the sense that it's just saying we consider all relevant facts and circumstances and the need to depose the lawyer or the lawyer's role in connection with what the matter is that discovery is being sought on. It's kind of like a weigh all the factors thing. It's not so much that you need to prove A, B, C, and D like the Shelton test is. So naturally, the lively parties are saying like the Freedman test applies in this case. Freedman test and Freedman lawyer is going to get confusing, but spelled differently for what it's worth. So they're arguing that the Freedman test applies, but they also say even under the Shelton test, they're entitled to this information because there's no other way to be able to show that actually the lawyers are witnesses in this case and are involved in this alleged retaliation. So what are they asking for? They're asking for a kind of wide array of things, but they're asking for Freedman's firm, any agreements that they've made on behalf of themselves or the Wayfarer parties with any content creators that have spoken publicly regarding any of the parties. They've asked for any payments made to any content creator for the same thing. They've asked for the financial institutions and names of the accounts that is held by the firm. And it kind of goes on, actually. There's quite a long list of information that they've requested from opposing counsel. Like phone logs, who has he called, who has Freedman texted, and who has he communicated with in the media. Just kind of broad brush, trying to find as much information as possible on who he has engaged with respect to the media and TikTok. For what it's worth, I think there's a very, very slim chance that this would be granted, especially in the format that it's in now. If anything gets granted, it'll be in the narrowest possible sense, and that's because there's too great of a risk with producing documents that could potentially have an attorney-client privilege attached to it. A court is not going to want to have that out in the public. It's very problematic. So there might be like an in-camera review, which means that the judge will look at it. And remember, this is not Judge Lyman. This is a Central District Court judge in California. And will look at whatever's there. And if it is deemed to meet one of the tests that the judge feels that it will apply, then at that point they might compel those documents to be produced. But until then, I don't know. I think it's a long shot.